sport for now. My name is Robinson Okenye, but I want to cross over to Makadara Law Courts, where the case for Maina Njenga is currently going on and the ruling is about to be made. And remember, at the top of the hour, Dennis Aseto will be with you to continue with that.
Moja ya sheria za uhalifu na maelezo ni kwamba nyinyi watatu tarehe 20 Julai 2023 katika eneo la Kiserian Kajiado County mlipatikana mkiwa mmejihami na silaha hatari ambayo ni shete 14, fiso ya Wamasai 24, rungu 46 na jembe kama miti za jembe 3 na kama sindano ambayo ilikuwa inaashiria mnataka kufanya uhalifu. Ni kweli ama si kweli? John Maina, Peter Njoroge, Felix Ratu, kuna shtaka la tatu. Shtaka lenyewe ni kwamba mmeshtakiwa na kosa la kupanga mkusanyiko wa watu ambao ni kinyume na sheria uhalifu, kifungu cha 511 ikisomwa na kifungu cha 510 ya usimamizi wa umma sheria za Kenya kifungu cha 56. Na maelezo ni kwamba ninyi wote watatu tarehe 20 Julai 2023 katika eneo la Kiserian Kajiado County mliweza kupanga mkusanyiko wa watu ambao ni kinyume na sheria ambayo ilikuwa imepangiwa ifanyike Nairobi City County na maeneo mengine nchini Kenya. Ni kweli ama si kweli? John Maina, Peter Njoroge, Felix Ratu, shtaka la nne. Shtaka la nne ni kwamba mmeshtakiwa na kosa la kusafirisha madawa ya kulevya kinyume na sheria kupambana na madawa za kulevya, na maelezo ni kwamba mmeshtakiwa na kosa la kusafirisha madawa ya kulevya kinyume na sheria kupambana na madawa ya kulevya, kifungu cha 4A ni nambari 4 ya 1994 na ile amended 4 ambayo ni 4A subsection 2 ya 2022. Na maelezo ni kwamba ninyi watatu tarehe 19 Julai 2023 katika eneo la Kiserian Kajiado County mliweza kupatikana mkiwa na madawa ya kulevya ambayo ni bangi yenye ilikuwa inatoshana na gramu 1224 yenye thamani ya shilingi 36,720, na pia mlipatikana na cocaine yenye uzito wa 400 gramu 486 yenye thamani ya shilingi 1,944 yenye thamani ya shilingi milioni 1,944 yenye ilikuwa imefungwa kwa plastic bag na ilikuwa gari aina ya Toyota Hilux registration number KCJ 419X. Ni kweli ama si kweli? John Maina, Peter Njoroge, Felix Ratu. Shtaka la mwisho na shtaka la tano, mmeshtakiwa na kufanya matendo ya kufasi ya kukidhi kinyume na sheria kifungu cha 77(1) ikisomwa na 77(3)(b) ya sheria za uhalifu. Maelezo ni kwamba ninyi watatu tarehe 20 Julai mwaka huu katika eneo la Kiserian Kajiado County kwa nia ya kuchochea watu wafanye upiganaji wa umma mliweza kupatikana mkiwa mmejihami na silaha ambayo ni mashete 14, panga za Wamasai ama fiso za Wamasai 24 na rungu 46 na jembe 3 ama miti ya jembe 3. Ni kweli ama si kweli? John Maina, si kweli. Peter Njoroge, Felix Ratu, si kweli.
We will then commission the court, Your Honor, before my colleagues address the court, and place on record Sharon Otieno, the defense team, Ayora. Sharon Otieno and Ayora Mugati, both appearing for the accused. colleagues can proceed to address you.
I've entered plea of not guilty in respect of all the charges the accused person are facing. Yes.
My colleague, Mr. Kemo, will like the same.
Mr.
Kemo.
Oh, Mr. Kemo.
Before he does, and I, on a light note,
Yes.
advise my friend here, miti ya jembe inaitwa mpini.
It's okay. Okay, proceed. Proceed, Mr. Kemo. Come, proceed.
Your Honor, the application before you is the one dated 24th of July. It's a notice of motion, 24th of July. It's a motion brought principally under 24 and 25, Article 49 of the Constitution, 24, 25, 49, 1, F and G, Section 36A, and Section 123A of the Criminal Procedure Act, the laws of Kenya. Your Honor, in the motion, we seek foremost to have this court deny the first accused bail. We do not object to the second and third accused being released on bail. And we'll also be praying that if the court deems it fit, it may grant whatever order it may deem just and grant and expedient. The application is supported by the affidavit of Chief Inspector Kipkemboi Rob, and it raises issues we think are compelling, we submit are compelling to persuade this court to deny the accused first accused person bail. We are also submitting, Your Honor, that there is a real likelihood that the first accused person is likely to commit additional or further crimes going by his character and antecedents, having recently been charged as recent as early as last month on 20th of June in Nakuru CM criminal case number E1171 of 2023. John Maina Njenga, Kamunya, and 11 others. And we have attached that to the affidavit of Chief Inspector Kipkemboi Rob. Rob is an investigation officer attached to the Serious Crimes Unit at the Directorate of Criminal Investigations, headquarters, and is the one responsible for the investigation of this matter. Your Honor, in this affidavit, he deposes that on the 18th of July, the DCI received some intelligence reports that a group of people were planning to commit crimes, including grievous harm, causing malicious damage to property during the demonstrations that had been planned last week. Yes. So, Your Honor, without repeating, let me just point out the compelling reasons. At paragraph 5, it is deposed that offensive weapons were recovered from the accused person. The charge sheet has indicated there were 14 machetes, 24 Masai swords, and 46 rungus and jembe sticks. We have attached the photograph of the offensive weapons recovered as KR1. I've also alluded, Your Honor, to the case that is before Nakuru Court. It is a case similar to the case before you, and it just goes to prove that the accused person, the first accused person, is a repeat offender. While the charges pending.
When you say offender, the trial has not been started.
It is prejudicial.
It is very prejudicial.
Well, I've not said that he's a convict.
Yes, then
the accused
you cannot use
has
those
not
terms.
been convicted by anybody.
Yes.
He is not a convict.
I'm saying, we cannot proceed like that. Let him address the court. After he's finished, we'll give you time to address.
Well guided them.
Your Honor, there's a case that I've already alluded to, 1171 of 2023, pending before Nakuru, that is based on similar circumstances and facts as this one. The point I'm making is the prosecution reasonably apprehends that if the accused person is released, he is likely to continue committing these offenses to the detriment of the public. Because we all know what the court takes judicial notice of what was happening in the country last week. There was chaos everywhere. And it is the responsibility of the government to ensure that there is peace and tranquil throughout the country. The other reason we raise, Your Honor, is that the first accused person is a very influential person.
That is prejudicial. Even though the owner of state need to have some order, they must object to that kind of submission. Because being influential, even if you are influential.
Yes, that's a model. You know, there's nobody here who can I think everybody knows it. So when you think it's, I'm not saying that I'm buying what you say, but everybody knows
Being influential, Your Honor, that's not really...
Okay, fine. Let it finish.
And the point I want to make about him being influential is that he is likely to instill fear and harm the witnesses that will come before this court to adduce evidence on the charges that have been laid against him this afternoon. Chief Inspector Kipkemboi also deposes that from their intelligence reports, there is a likelihood that the accused person's lives could be in danger if they are released. The first accused person. From other, it is there at paragraph 9, from other outlawed sects that could pose danger to him. The last reason we raise, Your Honor, is that there are accomplices of the accused who are still at large, yet to be arrested. And the release of the first accused person, whom I have already submitted, is influential, may prejudice the efforts to arrest his accomplices who are still at large. May we urge this court, Your Honor, to find that the reasons adduced in the affidavit of Chief Inspector Kipkemboi and the arguments we've made before you make compelling reasons that, and we pray that you be persuaded to deny the first accused bond. That is all, Your Honor.
I have 14.
No, but I gave you...
No, just 1 minute. 1 minute, there are 14 advocates appearing for this person. You cannot address me, all of you. So, I want the principals to address the court.
Can you give us 1 minute? We decide on that, on the same. We've already decided on 3.
On who is presenting the words. We are organized. Mr. Mimi McKinsey dealing with the tire in remote. Yes.
I just want to verify in like 3. Only
Very quickly, I'll deal with the confessional question, we'll deal with the legal question, we'll deal with the factual and the other things. Is that correct? Now, I'm starting with the confusion because it is the parent law. We submit that as a matter of course, even without us asking, you have to admit all the accused persons to bond. It is a constitutional right. If you look at Article 49, Clause 1I, it is very clear. You will not be given any compelling reason. Your Honor, compelling is something so violent that if it shook us in this house, the house will go down. That's compelling. Compelling if somebody is calling witnesses or he has sent them money through M-Pesa, that is compelling. Compelling is not an imagination of an individual or his whims. So, secondly, Your Lordship, if you look at Article 50, Clause 2A, there is a constitutional presumption of innocence. Everybody is presumed innocent. So that even if they have been charged, the Constitution protects them through the presumption of innocence. So they are presumed innocent until this trial is concluded. And for that reason, Your Honor, we pray that you give them, you admit them to bail. 3, if you look at Article 50, Clause 2, J and K, it says they must have time to study the judges and prepare their questions so that they are able to interrogate the evidence. They cannot do that in the confine of prison. They will do that better when they are released so that they can be able to prepare for their defense. 4, look at Article 27, Clause 1, 2, 3, and 4. Article 27, Clause 1, 2, 3, and 4. It is very clear, Your Honor. You cannot discriminate. These rights are donated to the individuals. And you cannot apply double standards, as the prosecution is trying to allude, that you can separate in one transaction which happened at the same time allegedly, and then you separate that accused one, I don't know what. And for your information, as an officer of the court, I can share with you that in that case of Nakuru, they have not supplied the defense with the trial documents. We were meeting on 18th of this month. They requested the court that they give us more time to supply the documents. I'm shocked to see the documents in this case, yet in Nakuru, they have not supplied those documents. The court can take judicial notice of that fact. And you can even call your colleague in Nakuru. They have not. And they even skinned them alive, that they cannot play around with the courts. Your Honor, you are not an extension of the police agency. You are not an extension of the DPP. You are independent and impartial under Article 160. So you look at all the circumstances of this case independently and come with an independent determination. 4.3, Your Honor, I'm dealing with the honorary constitutional questions. Look at Article 19.1 of the Constitution. It obligates that the Bill of Rights, Article 19.1, the Bill of Rights, Your Honor, is an integral part of our framework, or our socio and economic framework, so that nobody can try to separate the Bill of Rights from you. You have to address it. Look at Article 10, Clause 2C. It says the integrity of the process must be transparent, open, and accountable. So that, Your Honor, if the police are trying to hide something, or the DPP, you will tell them no. Look at the Constitution, Article 10, Clause 2C. It says the integrity of the process from initiation. These suspects have been held incommunicado since Thursday on 18th night. Now they waited until midnight to call it that it's on 19th, but they took them at 8 p.m. Time started counting immediately. They arrested them. They should have operated an open process so that if the family is calling them or anybody wants to see them, including counsel, they should allow them. They never did that. Now these suspects are subject of the court. There is no business of trying to tell us again that the police have anything to do with them. So you determine these issues according to your oath in the Constitution. Your Honor, I take you to Article 21.1. Article 21.1 is very clear. It states that every state officer, including judicial officers, including individuals, they must observe, promote, protect, fulfill the values and the principles in the Constitution. What are those values? They are those values of fair trial, values of access to justice. There are so many. We are saying this. These people have not committed treason. And even if they committed treason, they are still allowed to be released on bond. Your Honor, Article 24 limits the rights. But Your Honor, it says, it is very clear, Article 24, I think 2.4, close to 4. It says, the limitation should not be such that it changes the character of the right. The operational term, Your Honor, is the right to a fair trial and the right to liberty is sacrosanct. It's very fundamental and paramount. So, Your Honor, I rest my case because I believe that the Constitution gives you enough powers to give them, to admit them to bail without discrimination, and the international good practice, because our authorities, developed by Kenyan judges, have been quoted in Zambia, South Africa, and New Zealand, not because we are very special, but it's because we have followed the rule of law. We have followed what the courts decide. We have never gone the way of whims of individuals or impunity. So, Your Honor, I urge you to allow application for bond for all accused persons. Finally, I wish to address the fact that I gave you a copy of the ruling of the High Court, which shows that they were admitted by the High Court to bond. Your Honor, for wisdom and the consistency in terms of coherence of developing the criminal jurisprudence, it is important that you allow. My learned colleague was going to address that issue, but now you have limited us to 3. That's why I've decided to allow to mention it. But you will allow him to produce the authority. It will not take a lot of time on my behalf, Mr. Monje, so that he will explain to you that the High Court has given a bond for consistency in terms of criminal jurisprudence. It is only good order that you maintain that jurisprudence of consistency. Because law has a modicum of order. You can know where to find it. You can go to the Act, go to the Constitution, go to judicial precedents and find it. But these other issues are not settled. You have to run around looking for them. So at least let us settle that giving them bond is a settled issue. These other issues we can agree. So I've donated my minute. It's just provision to the authority so that they can deal with the law and the facts.
The authority, what to do? Read them.
Okay. Okay. Let me produce it on his behalf. Your Honor, the High Court have given you that, yes. And this is now judicial precedence. Yes. This is a petition number E001 of 2020. You look at it. Petition number E001 of 2020, and particularly I want you to look at paragraph 28. Because I don't have time, it is a petition. It's a last as Maina Njenga, the petitioner, versus the Machakos County Government and the AG. And if you look at paragraph 28 and paragraph 31, they are of relevance to this case, Your Honor. So I urge the court to allow to release all the accused persons to bond, reasonable bond, Your Honor. I will allow my my learned colleague to deal with the legal issues, and some fact, then my learned colleague will conclude unpacking the facts of this case.
Your Honor, my name is Brian Mwenda. Brian Mwenda. I'm on record. I would like to bring the court to the attention of the affidavit, the supporting affidavit of CIP Kemboi, Rob. And I go straight to number 4. It indicates paragraph 4. He says that on the 20th of July 2023, the 3 accused persons were arrested at Kiserian. I would like to correct, I would like to indicate to have the court note that that is incorrect. Our clients were arrested on 19th. So this...
Your Honor, sorry to interject. We respect that information, but counsel cannot say it from the bar. He should have an affidavit stating what he's saying. Those are matters of fact. And we respect him when he says that, but he cannot. The rules of
Your
the
Honor,
game can't say it
they've
from
only
the bar.
served us with the application, so it is only fair that we mention it. Because if they are presenting something verbally and it's contradictory to what is on the affidavit, which I was going also to highlight, there are quite a number of facts that are not in alignment. So it is not good practice, and it is not in the interest of justice that we allow that you decline to listen, to hear us.
Your Honor, again, unfortunately, counsel cannot give us matters of the facts from the bar. If he wants time to respond, he can seek time to respond and bring in an affidavit. He cannot speak to facts.
No,
He cannot. He was not there during the arrest, for example, so he cannot speak to the arrest.
Not doing matters which you know, I think it's correct on the matters of facts.
Now,
Maybe I should defend my colleague.
we just had that
Thank you. Let me just make one comment. If you look at the charge sheet, it talks about 19th and the 20th.
And the 20th. There's a contradiction.
So that's what I'm saying. It is important, therefore, that my colleague makes that reference to the fact of instructions, remembering that the accused persons have been held incommunicado. We were not allowed them to even to see them this morning until they came into court, and even as